Hey everyone, welcome back. Today I would like to discuss um, changes to the EB-1A visa for 2026. And I'd like to walk you through what's planned, what's rumored, and also a realistic timeline for any changes to take effect. And that way you know how to prepare. In the news, there's been quite a bit of information regarding a new rule that the Department of Homeland Security is preparing to modernize and clarify how the Immigration Service evaluates employment based immigration petitions, in particular, the EB-1A visa. So, let's break down what's likely to change and what's rumored. Okay, so what's very likely to change based on all the news that's been coming out is um, we should expect clearer, stricter evidentiary standards to be moved from the USCIS policy manual into formal regulations. So, in practice, that means there will be less variation between officers and more predictability. And um, along with that, of course, comes higher quality expectations for your evidence. But right now, we have the USCIS policy manual saying some things that are different or not contained in the regulation. So we have officers applying the law in very different ways. Um, so we should expect codifying current USCIS policy that's in the USCIS policy manual into official rules. We should also expect some clarification regarding what consists of sustained acclaim. And also, we should expect that the new rule will emphasize quality over box checking. And what does stricter evidentiary standards mean for an EB-1A visa application? So think about quality. I say this a lot, you'll probably notice in my videos. Think quality versus volume or quantity. Think impact. And evidence that really shows that you are at the top of your field. So, what is rumored? So let's see what is out there as rumors and not confirmed. There is there is a rumor that the Immigration Service could raise the threshold from 3 criteria to 5 criteria, or even tighten the use of comparable evidence, making it harder for some profiles to meet the requirements. However, again, these are rumors, but not confirmed in any published rule or text. So, what you can probably expect again is that there will be a higher standard to meet, but don't assume that there will be a requirement to meet more than 3 criteria. So let me give you a timeline for when any changes will take effect. So in January, we will, if they're moving forward with this, we will definitely see a draft rule or regulation put out there. It will be put out to the public for comment, which usually takes 30 to 60 days. Um, And then after that process ends, there will be a final rule, which will probably come out mid to late 2026. And then the effective date will likely be very late 2026 or early 2027. I mean, that's the standard procedure for publishing new regulations. Many times, however, this process stalls, so we may not even see anything next year. As you know, there is a tightening policy environment in general for immigration with regard to the EB-1A. My opinion is there will be more emphasis on the final merits, closer scrutiny of fraud, and vetting. And there will be a preference for clear, objective evidence of top tier achievement. So, this is um, we don't know for sure what will happen, but I think those are guaranteed. And then the bottom line is always to focus on quality over quantity, um, and expect clearer standards, codified standards, higher quality expectations. But along with that will come hopefully more consistent adjudications. So sometimes, one officer will grant one criteria and then another officer will not grant that criteria with the same evidence. So we're hopeful that these changes will bring uniformity. Change is not always bad. Um, and then again, what's rumored, not confirmed, is the higher criteria count. And then the timeline, if there's going to be new rules, would be late 2026, early 2027. If you need assistance, do not hesitate to contact my office, drop a comment, or reach out. We would be more than happy to help you. Thanks for watching, and don't forget to subscribe.